The most important thing to understand right now is that an arrest is not a conviction. Under California law, charges may not even be filed for weeks, and cases where no charges are ever filed are not rare. Until a court enters a guilty plea or a verdict, you are legally innocent. Most of the employment protections that matter attach to convictions, not to arrests, so that distinction is not just a technicality. It has real, practical weight when it comes to your job. California has some of the strongest worker protections in the country around arrest records. Under Labor Code Section 4327, most California employers cannot ask about an arrest that did not lead to a conviction, and they generally cannot use an arrest alone as the basis for terminating you. There are exceptions, though. Employers in law enforcement, healthcare, and positions that require a state license are permitted to ask more questions. The key takeaway is that an arrest by itself gives your employer far less leverage than most people assume. Probably not right away, but it depends on three things: your employment contract, your employee handbook, and your specific role. Most private employers in California do not require you to report an arrest before charges are filed or before a conviction. If your handbook has language like, "Report any arrest within 24 hours," however, read that carefully before you say anything. The handbook governs your obligation, so read it before you pick up the phone. If you drive commercially, a DUI arrest can trigger a disqualification process even before any conviction, and the rules for commercial driver's license holders are far stricter than for ordinary drivers. If you drive a company vehicle in a non-commercial job, your employer's insurance policy may require them to pull you off driving duties while the case is open. That is a contract and insurance issue, not a criminal law question. And if you hold a state-issued professional license, a DUI arrest can trigger separate reporting obligations to your licensing board entirely apart from what your employer does. Nurses, pharmacists, teachers, real estate agents, and many others have board-specific obligations, so the faster you understand what your specific board requires, the better. Beyond your employer's reaction, a DUI arrest immediately puts your driving privilege at risk through a completely separate DMV administrative process. If your license gets suspended and you cannot drive legally, getting to work becomes its own problem. A restricted license may allow you to commute while the case is pending. But you have exactly 10 days from the date of arrest to request a DMV hearing. Miss that window and the suspension goes forward automatically. The criminal case and the DMV process run on separate tracks with separate deadlines. The decisions you make in the next day or two can have a real effect on how your case develops. Do not post anything about the arrest on social media. Read your employee handbook before saying anything to your supervisor. If you are in a licensed profession or a safety-sensitive role, contact an attorney today, not after your first court date. And remember, there are steps you can begin right now, like enrolling in an alcohol education program, that can influence both the outcome of your case and how it looks to an employer down the road. Your job matters, and so does understanding exactly where you stand before you make any decisions. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.